For the first time since completing two federal criminal investigations that resulted in indictments against the sitting president, Jack Smith sat before television cameras and spoke publicly about his findings. The hearing room in the Rayburn House office building became, for a few hours, a stage for one of the most consequential confrontations in recent American political history. A former special counsel defending the rule of law against a Congress controlled by allies of the man he investigated. The weight of what unfolded was not lost on anyone watching. Smith's opening statement cut through the procedural noise with a directness that had been absent from his years of silence. He stated plainly that his investigation developed proof beyond a reasonable doubt that President Trump engaged in criminal activity. He said that if asked to prosecute a former president based on the same facts today, he would do so regardless of whether that president was a Democrat or a Republican. No one, he declared, should be above the law in this country. The law required that Trump be held to account. That is what he did. To have done otherwise, Smith explained, would have been to shirk his duties as a prosecutor and as a public servant. The context surrounding this testimony is critical to understanding why it matters. Smith was appointed special counsel in November 2022 by Attorney General Merrick Garland. His mandate covered two separate investigations. The first examined Trump's alleged efforts to overturn the results of the 2020 presidential election. The second focused on the handling of classified documents found at Trump's Mar-a-Lago estate after he left office. Both investigations resulted in federal indictments. Neither reached a jury verdict. Trump won the 2024 presidential election and returned to the White House in January 2025. Department of Justice policy prohibits the indictment or prosecution of a sitting president. Smith resigned just days before Trump's second inauguration. What remained was a final report documenting the evidence Smith and his team had gathered. The first volume, covering the election interference case, was released publicly. The second volume, concerning the classified documents case, remained sealed under a court order issued by Judge Eileen Cannon, a Trump appointee who had earlier dismissed that case entirely on grounds that Smith's appointment was unconstitutional. That dismissal prevented any trial from taking place. The sealed volume means that a significant portion of what federal investigators discovered about presidential conduct remains hidden from public view. Smith's appearance before the House Judiciary Committee came after months of maneuvering. In October 2025, his attorneys sent letters to both the House and Senate Judiciary Committees offering public testimony. The Republican-controlled House initially refused, issuing a subpoena instead for a closed-door deposition. That deposition took place on December 17, 2025, lasting more than 8 hours. The transcript, released on New Year's Eve, revealed Smith defending his decisions in blunt terms. He described Trump as the most culpable and most responsible person in the conspiracy to overturn the election. He stated that the attack on the Capitol would not have happened without Trump. The public hearing that followed was always going to be a spectacle divided along partisan lines. Chairman Jim Jordan opened by declaring that the investigations were always about politics. He accused Smith of obtaining phone records from Republican members of Congress, including former House Speaker Kevin McCarthy, for political purposes. Jordan framed the entire special counsel investigation as part of a decade-long Democratic effort to destroy Trump. He suggested that Smith had tried to stop Trump from running in 2024. The implication was clear. Republicans intended to use the hearing not to examine the evidence of presidential misconduct, but to prosecute the prosecutor. The Democratic response came from Ranking Member Jamie Raskin. He noted that for Republicans, this may be about politics, but for those who believe in constitutional governance, it is about the rule of law. Raskin acknowledged the presence of 4 officers seated directly behind Smith: Michael Fanone, Harry Dunn, Aquilino Gonell, and Daniel Hodges had all responded to the Capitol on January 6, 2021. They had testified before Congress in 2021 about their experiences fighting Trump supporters during the violent breach of the building. Their presence was a silent reminder of what the investigation had been about. Not abstract legal theories, but a physical assault on American democracy that injured more than 140 law enforcement officers. Smith's prepared remarks went further than his previous statements. He warned Americans not to take the rule of law for granted. He explained that through his career, including his work prosecuting war crimes in the Balkans and corruption cases in Europe, he had witnessed how the rule of law can erode. His fear, he said, was that Americans had seen the system function for so long that many had come to assume it would continue functioning indefinitely. But the rule of law is not self-executing. It depends on collective commitment. It requires dedicated service on behalf of others, especially when that service is difficult and comes with costs. The substance of Smith's testimony reiterated what his report had documented. Rather than accept his defeat in the 2020 election, President Trump engaged in a criminal scheme to overturn the results and prevent the lawful transfer of power. Smith outlined the specific conduct. Trump attempted to induce state officials to ignore true vote counts. He sought to manufacture fraudulent slates of presidential electors in 7 states he had lost. He tried to force his own vice president to act in contravention of his oath. And on January 6, 2021, he directed an angry mob to the Capitol to obstruct the congressional certification. Then he exploited the rioters' violence to further delay the process. Smith emphasized the quality of his witnesses. Some of the most powerful, he noted, were fellow Republicans who had voted for Trump, campaigned for him, and wanted him to win. These included state officials like the Georgia Secretary of State, who told Trump the truth about the election results. They told him things he did not want to hear. They put him on notice that what he was saying was false. The evidence did not come from partisan opponents. It came from Trump's own allies who reached the limits of what they would do to keep him in power. On the classified documents case, Smith was constrained. Hours before his December deposition, the Department of Justice sent an email to his attorneys, preventing him from discussing that investigation due to the ongoing court injunction. He told lawmakers he did not want to violate that order. This meant that substantial portions of the hearing could not address one of the 2 major investigations he had conducted. The public remains in the dark about the full scope of what investigators found regarding Trump's handling of classified national security materials. The political dynamics surrounding this testimony reveals something important about the current state of American governance. Trump has repeatedly called for Smith to be prosecuted. At a press conference earlier this week, the president referred to Smith as deranged Jack Smith and called him a sick son of a bitch. Trump has suggested at various times that Smith should be criminally investigated or even expelled from the country. Smith acknowledged in his testimony that he has no doubt the president wants to seek retribution against him. This creates an unprecedented situation. A former prosecutor who gathered evidence of criminal conduct by a president now faces potential retaliation from that same president after his return to power. Smith noted this dynamic in his remarks, criticizing what he described as retribution carried out by the president and his allies against agents and prosecutors who investigated the cases. The chilling effect on future law enforcement officials is obvious. Anyone who investigates a powerful political figure must now consider whether that figure might one day be in a position to punish them for doing their job. The hearing also exposed the limitations of congressional oversight when controlled by allies of the subject being investigated. Republicans focused their questions not on the evidence Smith gathered, but on procedural complaints about how he gathered it. They questioned why phone records from Republican senators were subpoenaed. They challenged the timing of indictments relative to the 2024 election. They portrayed every investigative step as evidence of political motivation, rather than examining whether the underlying conduct warranted prosecution. Democrats attempted to use their questioning time to draw out details about Trump's actions. They highlighted findings from Smith's report. They asked about specific witnesses and specific evidence. But the structure of a congressional hearing, with limited time for each member and no opportunity for sustained cross-examination, meant that the depth of inquiry remained shallow. The public learned relatively little that was not already in the transcripts and reports previously released. What the hearing did accomplish was putting a face and voice to the investigation for the first time. Smith had been a largely silent figure throughout his tenure as special counsel. He made brief public statements when announcing indictments, but otherwise allowed court filings to speak for him. Now, sitting before cameras, he could articulate his reasoning in his own words. He could respond to accusations directly. He could look members of Congress in the eye and state that he acted without political motivation and would do the same again. The broader implications of this moment extend beyond any single investigation. The question at the heart of Smith's testimony was whether American democracy can hold its leaders accountable under law. Trump was indicted twice on federal charges. Neither case reached a jury. He was elected president while under indictment. He returned to power and the cases were dismissed not because he was found innocent, but because the Justice Department concluded it could not prosecute a sitting president. The evidence Smith gathered sits in files that may never result in legal consequences. Smith's warning about the rule of law resonates in this context. The system did not fail because prosecutors lacked evidence. It did not fail because investigators were insufficiently diligent. It failed because the timing of justice did not align with the timing of elections. A president can apparently commit crimes, face indictment, win an election, and then see those cases dissolved by his own return to power. Whether this represents a design flaw in American constitutional structure or simply an outcome that the founders never anticipated remains a question that legal scholars will debate for generations. For now, the record exists. Smith compiled it. He presented it to a grand jury. He secured indictments. He submitted a final report documenting his findings. And now, for one afternoon, he defended it publicly before a Congress that seemed more interested in punishing him than examining the evidence he had gathered. The cameras have moved on. The hearing has ended. But the questions it raised about accountability, power, and the future of American democracy remain unanswered.